Hello and welcome to the Indiana Lawyer Podcast, your source for news and Hoosier law brought to you by Taft. I'm Alexa Shrake, Indiana Lawyer Reporter, and your host this week. I'm here in our Monument Circle studio with Indiana Judges and Lawyers Association Executive Director Terry Harrell. So to start, Terry, tell us a little bit about yourself and how you got involved with the Indiana Judges and Lawyers Association.
Thanks for inviting me, Alexa. How I got involved, that's such an interesting question. I think at the beginning of my career, people probably thought, what on earth is she doing? Because I had a terrible time deciding what I wanted to do. And yet when I look back closer to the end of my career, it looks like everything happened just how it was supposed to, like it was perfect experience for working in a lawyer assistance program. My senior year in college, I had applications for a PhD in psychology, a law school application, and then an application for the Peace Corps. In the end, I applied for the PhD program and got accepted. And then at the last minute, I changed my mind and went back and went to law school. After law school, I worked in big law for a little while and clerked for an appellate court judge. And then I decided I really did want to be in the mental health field. So I went back and got my MSW. And for 10 years, I worked for a community mental health center, one place the whole time. But I moved around and worked in kind of all levels of care with different kinds of mental health issues and saw different aspects of the mental health system. And then around 2000, they hired the first director for the Judges and Lawyers Assistance Program here in Indiana. Her name was Susan Eisenhower. They hired her in the fall of 1999, and she was fabulous at creating a program that hadn't existed until they hired her. And she knew a lot about substance use, but not as much about mental health. And a good friend of mine was talking to her and said, oh, I have a friend from law school who works in mental health. The two of us met, hit it off. And so by summer of 2000, then she hired me to come in as the clinical director. And I mean, we've been full speed ahead ever since then. And it's kind of fun to see how this tiny little program that no one knew about became this well-established agency with over 300 volunteers around the state, doing all the things that we do today. So it's been a great ride. And I feel like, unbeknownst to me, all the experiences I had built up to serving the lawyers that we do today as well as I can.
And so the JLAP for short is what it stands for, Indiana Judges Lawyers Association. It was established in 1997, correct? So almost
correct.
30
The rule
years.
was written in 97, and then they hired a part-time director while they looked around for a full-time director. So even though it was created in 97, they didn't hire the full-time director till fall of 99. Another helpful piece when we talk about lawyer assistance program all over the country, they refer to themselves as LAPs, lawyer assistance programs. And then some of us put the J in it, JLAP for the judges, but collectively we call ourselves LAPs.
So can you kind of walk us through some of the things and resources that JLAP offers, for attorneys?
I would love to. I think a lot of people aren't aware of everything that we do. Let me start by reading our mission statement. I think that's helpful. JLAP provides confidential, compassionate support to all judges, lawyers, and law students by promoting well-being, improving lives, fostering connection, and thereby elevating the competence of our profession. That's our mission. So really, our goal is to assist all members of the legal profession in thriving. So it might be that we make a referral to a therapist to help someone with depression or situational stress, maybe an alcohol problem. It might be that you just sit down with one of our staff and work on how to improve the quality and quantity of your sleep. Might be that simple. It all starts with a call or an email to our office. We actually have an intake form on our website if that feels more comfortable that you can fill out, but a simple phone call will work as well. Our office manager or someone else on staff will take down the general information, why you're calling, and then figure out which case manager would be most helpful to you in your situation. You'll then sit down, and of course, sit down might mean on Zoom, it might be on phone, or it may be in person at our office or at your office, wherever you prefer, and talk over the situation with that staff person, kind of a consult. They'll have some ideas and some options and work with you to create a plan or figure out at least what the next step is in the process. It can look very different for different people. Maybe at the end of the day, we offer to loan you a book from our lending library. Might be that simple. Maybe it's a referral to a therapist, a psychiatrist, a neurologist. maybe a support group that JLAP runs or someone else runs, maybe to a JLAP volunteer. The heart of lawyer assistance programs comes from the idea that the best starting point may be to talk to another lawyer about your situation in a completely confidential, someone you can talk to completely confidentially, someone that's not involved in your work situation, doesn't have other motivations, that's just there to help you solve your own situation. So the important thing is no matter how unique your situation is, it's always worth a call to see if JLAP can help. Maybe we can't, but it's a confidential call, so you've never lost anything. And we've probably seen it before, but if we haven't, if you really do have that really unique situation, we have a team of lawyers, social worker, mental health type professionals that are really good at finding resources. So if it's something we haven't seen before, we may be able to find something even though we haven't seen it before. So it's worth a call. We do run a wide variety of support groups. We have ongoing groups that go for years. Most of them meet once a month. One meets twice a month. We also occasionally offer a time-limited group for maybe 6 weeks in a row or 8 weeks in a row. I'm not going to list all of them right now because we're currently reviewing all of our groups to decide which ones are most effective and successful, and we may drop some and add some new ones. I'm 99.9% sure we will continue with our addictions group and our grief group. But if you're interested about any kind of support group, give our office a call. You might give us the idea that we need to start one in a different area, or we can tell you what we currently have and what we will be offering soon. Another thing we do monitor lawyers occasionally for, say, lawyer or judicial discipline, or for an employer sometimes on kind of a last chance agreement. And you see some of the disciplinary reports come down in the Indiana Lawyer, so you know about those. First thing I want to say is those cases make up less than 5% of our cases. So the 95% of our cases are ones that you will never hear about. You will never see anything in the Indiana Lawyer. But we do monitor, because what that does is it holds the individual accountable for working their own treatment plan that their own treatment providers have said are good for them, and it protects the public. So we're doing two things at the same time, and no one would ever be surprised by this. There must be a release signed. There will be a written agreement. No one will ever be caught by surprise that they're being monitored by JLAP. They will know well in advance that it's going to happen, and they can say no if they don't want to do that. But that's one thing we do. The thing we've done more of recently that people may not know about is that we do offer some crisis response assistance to organizations. If in your law firm or in your court, there is some traumatic event. We're human beings and occasionally things happen. We've had someone walk into a law firm with a gun, firing a gun. Sometimes there's an unexpected death and people are traumatized. We have a little menu of how we can help that ranges from we can just come drop off some JLAP brochures if somebody wants to contact us individually, or we can come in and do a group debriefing. We can come in and bring our therapy dogs, or maybe just have individual people available to talk one-on-one. There's a number of options that if someone wants to call our office and say, hey, we had this thing happen. People are really distressed. Can you help? We can say, yes, these are some of the things we offer. What would work best for you? And then we'll tweak it depending on what that organization thinks would be helpful. The final thing I say is we do a lot of education. Last year, we did just over 100 presentations. The goal is to educate the community, first of all, about what JLAP does, but also about the various issues that lawyers often struggle with. So some of our common topics are micro-resilience, compassion fatigue, perfectionism, and believe it or not, we still do JLAP 101 pretty frequently. It's so funny. I thought in 2000 that we'd do JLAP 101 for a year and we'd be done and move on, but we still find there's people that don't know much about JLAP, so we still do that presentation pretty frequently. So This is wonderful. I'm glad we're doing the podcast.
We are in a new year, and I was wondering, is there anything else like that JLAP is looking to do in 2025? Something new, or just...
I think the two things we're going to focus on in 2025, we're really ramping up our volunteer program, I would say. We have just about 300 volunteers, and so we want to make sure we're providing them with the best education, more frequent communication, better able to pair the right volunteer with the right caller to our office. We've revised our handbook, so we're really ramping up on that piece, which, of course, for our callers is pretty invisible, but it's really important to the work that we do. And then the second thing is our groups. I think you'll see some changes. If anyone's been to a presentation and we have a slide that shows all of our groups, I think that's probably going to change. So I guess I would invite anyone who is looking for or thinks there's a support group that needs to be done to give us a call. Now is the time, and I think if we can accomplish those two big goals along with doing our day-to-day work, we'll be in good shape.
Yeah, that's excellent. What is a misconception that people sometimes have about JLAP?
There are several.
Yeah.
The big two. The first one is people think JLAP is only for people who drink too much. I mean, I have literally been talking to someone and had them say, oh, gosh, last year Susie was so depressed after her mom died, but we knew she didn't drink, so we never thought about referring her to JLAP. And I'm like, at the time we had a depression group and a grief group that we could have referred her to. We want to make that clear that we are very broad brush, and we have been since 1997 when we were created. However, and what happens is often, I will say, it is a lawyer who's been in the profession for some time who thinks we only deal with alcohol, but then they tell a younger lawyer that, and the myth continues. Now, the older lawyer isn't crazy. Lawyer assistance grew out of a volunteer effort by lawyers who were recovering mostly from alcohol problems to assist their colleagues who were struggling with alcohol problems. And then over time, it expanded. By the time we got to the 1990s, most programs, including JLAP, were designed to be broad brush. We'll help with mental health. We help with, it can be a physical health problem. Now, we don't treat your cancer or your heart disease, but there are emotional issues that come with those physical conditions, and we can provide support for that. We do mental health. We do process addictions. We certainly do all substance addictions, not just alcohol. But because our roots back in the 70s and 80s were there, it's been a really tough myth to dispense with. The number two, the second one is, and we still to this day hear this, that they believe the JLAP staff are really spies for the disciplinary commission. There are people that just are convinced if you tell JLAP something, that information will go straight to the disciplinary commission. That could not be further from the truth. We are both Supreme Court agencies, but we have our own confidentiality rules. There's many, many things that we cannot share with the disciplinary commission. There are things the disciplinary commission can't share with us, and we have to abide by those rules. You can find JLAP's confidentiality rules in Rule 31 of the Admission and Discipline Rules and Rule 8.3 of the Rules of Professional Conduct. If you read those two together, you will understand where our confidentiality comes from. It's really not complicated, though. Basically, all contact with JLAP is confidential with two exceptions. The first is if a person signs a release of information for us to speak to someone, and that happens with some frequency. Someone wants us to talk to their therapist, they want us to talk to a spouse, or they're in trouble with their law firm and they want us to verify that they are working with JLAP and have a plan of action, and so they sign a release. The second exception would be for just imminent suicidal, homicidal intention and thinking. And even then, we're going to do what we need to do to protect safety. We're going to call the police. We might call someone's psychiatrist, call their own spouse. We might drive them to an emergency room. We'll do the minimum that is, as far as telling other people, we'll talk to as few as possible to provide safety. But we're not going to call the disciplinary commission because they're not the people to help in that situation. We're not going to call the Indiana lawyer or the state bar or the Indiana Supreme Court. We're merely going to call the medical or emergency professionals to help solve that situation. So it really, really is confidential. And that has been a hard thing for lawyers to accept. I guess there's two small ones that don't come up nearly as often. One is our name is lawyer assistance, but we don't provide paralegal assistance, legal assistance, transcription assistance, and research. And sometimes lawyers, usually it's out-of-state lawyers, will call us thinking that's what we provide. So we don't do that. And then we don't provide the end therapy. So no one at JLAP would be someone's primary therapist. We're more of that bridge in that we help people figure out what they need and get them to the correct resources. And then we provide a lot of support along the way through our staff, through our volunteers, through the support groups, but we're not going to be anyone's primary therapist. And occasionally people get that confused.
So I know you will be attending the Institute for Wellbeing conference. Can you tell me a little bit more about that?
The Institute for Wellbeing and Law, or IWIL as we call it, everyone has their acronyms. So IWIL is a really great organization that grew out of the 2016 research on lawyer mental health and the 2017 task force report on what the legal profession can do to change our culture to better support well-being for everyone in the profession. And really the unique niche that it filled was looking at what our institutions can do. What can the legal employers do? What can the judiciary do? What can bar associations do to make our culture one that is better for everyone in it? The conference is 100% remote and has been always, because I think it started right about pandemic time. And I've attended it in the past, and they do a really nice job of providing interaction as well as you can in a remote conference. And I recognize a lot of the speakers this year. They're really good. So I will be attending. My expectations are really high. And as I understand, you can register almost right up into the last day because it is a remote conference. So they don't need to worry about head counts or meals or any of that kind of stuff. So unlike most conferences, you can sign up right at the last minute.
Are there many other JLAPs in other states?
Yes, almost every state has a lawyer assistance program. They vary a little bit in what services they provide and so the scope of their services and their staffing, but every state has one. And if anyone needs to be connected, we can probably connect you to the LAP in any other state. There are a few that are purely voluntary programs, but that's less than a handful, I think, at this point. I will say that our surrounding states like Michigan, Illinois, Ohio, Kentucky, they all have really robust lawyer assistance programs. Talking about lawyer assistance programs, I forgot to tell you something about the conference, the IWIL conference, that they have 4 tracks this year. One is on individual well-being. So if you want to attend just to learn how to improve your own well-being, there's a track. If you're interested in how to make your firm or your agency better for the people that work there and increase the organizational well-being, there's a track. Then there's a track for both state lawyer assistance programs and state well-being task forces, because some states have task forces looking at how to improve well-being in the legal profession. And the 4th track is teaching and promoting well-being in the law schools, which the law schools have made huge strides about law student well-being in the last few years. So there's a little bit of something for everyone at that conference.
Since you mentioned law schools, law students are also part of JLAP,
Absolutely.
Right?
We serve law students. Sometimes I have to remind the faculty at the law school that we also serve them. If they're lawyers, we serve them as well. But yes, we do a lot at the law schools. We have a person, 2 separate people. One person goes down to McKinney and another goes to Maura once a month and has office hours so they can meet with them right there at the law school. But of course, a law student can call anytime and schedule an in-person or a Zoom meeting. We participate in a lot of those well-being activities at the law schools as well. We take the therapy dogs over, hoping that if the law students get used to seeing us and thinking about well-being, that will then carry into their professional life, and they won't hesitate to call JLAP.
Mm-hmm. Yeah, well, that's excellent. Looking at my questions here, I think that's everything. Is there anything else that you just want to add that I didn't think to ask you?
I guess my final word would just be remember to call JLAP early. Don't wait. There's no downside to calling. It's a confidential call. The very worst thing that could happen is we don't really have an answer for or a suggestion for you. And whatever you do, don't wait till things have gone horribly wrong. We will still help you when things are really, really bad. But if you call earlier, there will be many more options and it'll be easier for us to help you. So call when you think things just aren't right. Maybe my values don't match with my firm's values. Something's just off. Maybe I'm not sleeping right. Give us a call, because our goal isn't just to help people who are in terrible, terrible straits. We want to help all lawyers thrive. So call us whenever we can help you to do better and to thrive.
Well, excellent. All right, that'll do for this week's interview. Terry, thank you again for joining me today. And to our listeners, stick around after our sponsor break to hear this week's headlines.
Taft Today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Welcome back. Managing Editor Daniel Carson and reporter Maura Johnson and I are here in our Monument Circle studio to give you the rundown on the latest legal news. So, let's get started. Today is Wednesday, January 22nd, 2025. Maura, you have news on a judge being reprimanded. What can you tell us?
The Indiana Supreme Court issued a public reprimand for a Putnam County judge who is found to have engaged in misconduct by making injudicious comments about unmarried women bringing property claims against their former partners. The case against Putnam Superior Court Judge Charles D. Bridges was brought to the High Court in December. It stems from a November 2021 complaint a woman filed against her former romantic partner, arguing she was entitled to some of the proceeds made from the sale of the home she and the man shared. According to the complaint, the house was in the partner's name, but the woman helped maintain and rehabilitate it. During an attorneys-only pretrial conference in March 2022, Bridges allegedly made several remarks expressing his negative perception of the legal cause of action between two parties who had lived together but weren't married. Prior to this case, Bridges had received 2 private cautions for violating Indiana Code of Judicial Conduct rules in 2015 and 2019.
Thanks, Maura. Indiana Attorney General Todd Rokita has released the details of his proposed rule changes for attorney discipline, calling on Indiana Supreme Court Disciplinary Commission to quickly dismiss politically motivated complaints against attorneys and follow the same impartiality guidelines as judges. The proposals escalate ongoing differences Rokita has had with the Disciplinary Commission since he was reprimanded by the Indiana Supreme Court for comments he made in 2022 about a doctor who performed an abortion. He also became the subject of at least 3 more disciplinary complaints that dogged him throughout his re-election campaign last year, and that he considers purely political. Rokita generally suggested some disciplinary rule changes at a news conference immediately after his re-election in November, where he called for the commission to protect the free speech rights of attorneys. He did not release his written rule proposals until Indiana lawyer filed a formal request for the records under the state's Access to Public Records Act. The proposals were submitted to the Indiana Supreme Court's Rules Committee on November 8th. His proposed rule regarding politically motivated complaints is a response to grievances filed by Bill Groth, a labor union attorney who was named the Indiana Democratic Party's Activist of the Year in 2018, and Paula Cardoza-Jones, who worked as a staff attorney for the state's Supreme Court's Administration Office and the Disciplinary Commission. Rokita's proposal would require that disciplinary complaints be based on personal knowledge of the situation, not politics. Rokita's call for impartiality stems from a situation in which Lake County Prosecutor Bernard Carter, a member of the Disciplinary Commission and its former chair, endorsed Rokita's Democratic challenger Destiny Wells, while complaints regarding Rokita were potentially pending before the commission. Rokita's proposal would have Indiana Disciplinary Commission members be bound by the state's rules of judicial conduct. Those rules prohibit judges from publicly expressing their political views, endorsing candidates, or making political contributions. A 3rd Indiana University men's basketball player joined a lawsuit against a former team doctor. Daniel, what can you tell us about the litigation?
A 3rd former Indiana University men's basketball player has been added to a lawsuit alleging the university did nothing to stop repeated rectal exams the players received from former team physician Dr. Brad Bomba Sr., acts that they say constituted sexual abuse. John Flowers, a 1981 McDonald's All-American high school player who played at IU from 1981 to 1982, has joined the complaint as an additional plaintiff. Flowers joins former players Charlie Miller and Harris Musenovich as plaintiffs in that class action lawsuit, which was filed in the U.S. District Court in Indianapolis. Kathleen Delaney of Delaney & Delaney LLC is representing the 3 former IU players. Players allege that Bamba, the team's physician, routinely and repeatedly subjected the players to medically unnecessary, invasive, and sexually abusive rectal examinations. IU spokesman Mark Bode told Indiana Lawyer the university does not comment on litigation. Bode provided a link to the university's September 2024 statement where IU announced that, in response to learning of the allegations, the university retained international law firm Jones Day to conduct an independent review. Court documents showed the plaintiffs deposed Bamba on December 4th. The documents allege that during a deposition lasting less than 75 minutes of on-the-record time, quote, Dr. Bamba Sr. invoked his Fifth Amendment privilege against self-incrimination and refused to answer more than 45 questions on the advice of legal counsel.
Thanks, Daniel. U.S. Attorney for the Southern District of Indiana, Zachary Myers, has resigned from his role. First Assistant U.S. Attorney Jonathan Childress will serve as the district's acting U.S. Attorney under the Vacancies Reform Act. Childress first joined the Department of Justice as an Assistant U.S. Attorney in 2001. He previously served as both First Assistant U.S. Attorney and acting U.S. Attorney for the Southern District of Indiana and the Central District of Illinois. Before becoming a federal prosecutor, Myers worked in the private sector on Capitol Hill. He grew up in Indianapolis and is the first Black person to serve as the U.S. Attorney for the district. Myers was sworn into the office in November 2021. He previously served as Assistant U.S. Attorney for the District of Maryland. He worked in the Baltimore Division's Major Crimes Unit and in the District of Maryland's National Security and Cybercrime Section, serving as the first cybercrime counsel for the district. He has also served as a computer hacking and intellectual property prosecutor and as national security cyber specialist. Myers was Assistant U.S. Attorney for the Southern District of Indiana from 2011 to 2014, where he worked in the General Crimes Unit and led investigations, prosecutions, and appeals in a range of federal offenses. His focus centered on technology-facilitated crime, including cyber crimes, national security offenses, public corruption, violent crimes, and sex trafficking. Myers, who worked nearly 3 years as an associate at what is now Faegre Drinker, Biddle, and Reith, was nominated by former President Joe Biden in July 2021 and unanimously confirmed by the Senate. Under Myers' leadership, the U.S. Attorney's Office focused on gun violence, drug trafficking, hate crimes, human trafficking, and fraud. He was chosen in July 2022 to chair the Attorney General's Advisory Committee's Cyber and Intellectual Property Subcommittee, tackling issues at the intersection of law enforcement and high technology. I am working on an upcoming story about Myers' career, his next steps, and the process of filling his vacancy. Now, going back to Daniel for news about a former Newcastle officer being sentenced.
Former Newcastle police lieutenant was sentenced to more than 12 years in federal prison after allegedly using excessive force against people in custody and obstructing justice by attempting to deceive investigators. The U.S. Department of Justice announced that Aaron Jason Strong, 47, faces 151 months in prison after a federal jury convicted him in October of 3 counts of deprivation of rights under color of law and 1 count of witness tampering. At trial, evidence introduced by the government established that Strong had intentionally used excessive force against people in police custody on multiple occasions. In August 2019, then Lieutenant Strong responded to another officer's report of a foot chase. As Strong arrived, the suspect stopped running, put his hands up, said, "I'm done," and lowered himself to the ground. As another officer approached to take the suspect into custody, Strong ran up and struck the suspect at least 12 times with a metal police baton, nearly striking a fellow officer. Other involved officers promptly reported the incident, and the Indiana State Police were called in to conduct an independent criminal investigation. During a meeting with the state police investigator, Strong gave a false account of the incident in which he minimized his own use of force and exaggerated the danger posed by the suspect. Strong was also convicted of using excessive force against 2 men being detained pending trial in a low-security annex of the Henry County Jail. While assisting correctional officers with a dormitory search, Strong stomped on the head of a detainee who was complying with commands to lie on the ground. A few moments later, Strong approached a second inmate who was kneeling, not moving, with his back to Strong, and shot him point blank in the back with a less lethal beanbag round, which Strong had been trained could cause death or serious bodily injury when used at short ranges. The impact from the round fractured the detainee's spine.
Thanks, Daniel. A Kentucky woman found guilty of embezzling more than $1 million from a family-owned Greenfield business has been sentenced to 2.5 years in federal prison, the U.S. Attorney's Office announced. U.S. District Judge James Sweeney II sentenced Jennifer Lynn Horton, 49, of Shepherdsville, Kentucky, to 30 months in federal prison, followed by 1 year of supervised release after pleading guilty to 2 counts of wire fraud. In addition to her prison sentence, the court ordered the forfeiture of Horton's interest in 4 vehicles, a 2022 Ford F-350, a 2022 Ford Mustang, a 2021 Ford Mustang, and a 2020 Ford EcoSport, and that she pay a judgment of $1 million. According to court documents, between 2011 and 2022, Horton worked as an office manager for a family-owned contracting company located in Greenfield. In that role, Horton was responsible for managing payroll, customer invoices, and company credit cards. Beginning around 2016 and continuing through December 2022, Horton devised and executed multiple schemes to defraud her employer of more than $1 million. First, Horton inflated her salary on 466 separate occasions without approval. In December 2020, Horton added her husband to the company's payroll, even though he had not been hired as a salaried employee. To conceal her conduct, Horton edited the company's payroll data to make it appear that she was being paid her agreed-upon salary and to delete the payments to her husband. Lastly, Daniel, you have news about a class action lawsuit in Elkhart.
A split Indiana Supreme Court ruled the Indiana Medical Malpractice Act does apply to claims in a class action lawsuit brought in Elkhart Superior Court on behalf of patients against an unspecified hospital. The High Court affirmed the lower court's ruling on the application of the MMA, but reversed the trial court's denial of the patient's motion for class certification. The court found that the law covers all claims for medical malpractice, as that term is defined, and is not limited to claims only involving bodily injury or death. It also ruled that the trial court had jurisdiction to preliminarily determine class certification and remanded the case for the trial court to consider the plaintiff's certification motion. According to court records, Linda Jyrek was one of more than 1,000 patients who had a surgical procedure at an unspecified hospital and who were later informed that one of the hospital's technicians didn't complete a step in sterilizing surgical instruments. Jyrek and her husband filed a class action complaint with the Elkhart Superior Court and a proposed class action complaint with the Commissioner of the Indiana Department of Insurance, asserting claims against the hospital for negligent infliction of emotional distress, negligence, and in the alternative medical malpractice. The Jyreks also filed motions requesting the certification of 2 classes, one for the hospital's patients and another for patients' spouses. Justice Christopher Goff, writing for the majority, said the court concluded that the MMA covers all claims for malpractice by a patient against a healthcare provider, as those terms are defined in the Act, and that nothing in the state's complaint statute limits the scope of coverage. Quote, "Our conclusion follows from the plain language of the complaint statute, and it aligns with decades of precedent, the Act's legislative history, and its overarching purpose. What's more, our reading of the statute ensures compliance with the MMA's statute of limitations by patients, like those here, that may suffer from a latent bodily injury following an act of malpractice," Goff wrote in an opinion joined by Chief Justice Loretta Resch and Justice Mark Massa. The court also ruled that the trial court had jurisdictional discretion to preliminary determine class certification in the case.
Thanks, Daniel. And to finally wrap up this week's headlines, Maura, tell us about what you are working on for our next print edition.
For our next print edition, I'm looking at a new bill introduced in the Senate that could make the possession and use of radio frequency jamming devices a felony. Hear from the author of the bill and learn how other states are regulating the devices in our January 29th issue.
Okay, that'll do for this week's headlines. As always, if you want more legal news, check us out at theindianalawyer.com.